rise. The Court of Appeals, Division 1 is now in session.
Thank you. You may be seated. So we are here on our case number 1CACV180185FC Cohen versus Cohen. As both of you have been here before, let me see you over there. Each side's allotted 20 minutes for your argument. The appellant may reserve any amount of time you'd like to use in rebuttal. If you do decide to reserve time, though, you're in charge of keeping track of it for yourself, because the clock on the podium will reflect the total amount you have remaining, including what you might have decided to reserve. We record the proceedings, so we'd be grateful if you would please give us your name and the name of your client when you approach the podium. We've reviewed the record and have studied the briefs. We've also discussed the case in a conference together. So with that, you may proceed.
Good morning, Your Honors. Judge Brown, Judge Johnson, Judge Perkins. May it please the Court, my name is Sandra Slayton, and I'm here representing appellant wife Noreen Cohen. I think the most, what I'd like to start with is the argument on spousal maintenance. Husband was making $88,000 a month, had $20 million to his name. Wife, $3 million, and then a house, of course, that is still on the market. And the judge went through every factor under 25319 and just came to the conclusion that it should be zero. I think that's an error, an abuse of discretion as a matter of law.
Help us understand, given the nature of the proceedings below, a report issued by the master, converted into an order by order of law, according to the rules, and then the judge denied your client's motion for a new trial. Whose abuse of discretion are we reviewing here? The family law masters or the trial court when it denied your motion for a new trial?
That's interesting, Your Honor. It is like we appealed from the decree, and I just want to clarify something, if I may, respectfully. It was a dismissal of my motion for new trial, so the trial judge didn't even consider it on the merits. He ordered it dismissed.
How do you know that, other than the word dismissed?
Because that's what he ordered, that he said it was dismissed. So you can't dismiss, and the other side argued that the motion for new trial should be dismissed. It was a motion to dismiss by husband's trial counsel. So, and the reason for the motion to dismiss was this misguided, I believe, principle that, or interpretation of Rule 72F, which really, it says no further pleadings shall be filed in conjunction with challenging the special master's report. It doesn't say you can't file a motion for new trial, because, and the judge, and we said that, but the judge just apparently accepted their reasoning. He didn't say, well, I'm going to consider this on the merits, and I'm denying it. That's another argument. But to get back to your question, I think it does convert technically into the trial judge's abuse of discretion as a matter of law, because the court adopted that as its own order. That was in the decree. So that's technically what it is. But, I mean, all of the reasoning and everything was given by the special master, and that's why it's referenced that way. So the court adopted that. The court didn't hold a hearing or anything like that.
But the only thing that the court did is to dismiss your motion for a new trial and then enter the decree accordingly.
Yes, and we're appealing from that.
Right.
And that has to be based on the special master's report.
Counsel, on the motion for new trial, the judge did also deny your motion for new hearing, so denied that motion.
Yes.
And the two motions were substantially the same, weren't they?
Well, the motion for a new hearing, it was those were my renewed objections, I believe, to the fact that all of these procedural deficiencies existed before the special master. For instance, the special master was the mediator and he was the arbitrator, and there was no transcript and all of that. So to that extent, yes. And really the motion for new trial addressed that. But in the end, we appealed a decree that this was a big issue in the appeal, in my appeal. So that's what I believe is just the essence of the substantive abuse as a matter of law, abuse of discretion as a matter of law that the special master participated in. He went through all of the factors. I mean, it's right in his report, and you don't have to go to any parts of the record to get that reasoning. The special master, adopted by the trial court, so it became the trial court's order, became part of the decree, went through every single factor in 25319B and said that my client, wife, met all of these factors, but just grabbed onto one and said, and didn't weigh the other factors, and just said because she has sufficient income to take care of herself, he's just not going to give her any spousal maintenance. I don't think that's the law under Rainwater. And Thomas v. Thomas, I quoted Rainwater on page 27 of my brief. I think this court was very careful to talk about the equitable considerations. It isn't just that one thing. It's the standard of living. The judge found that they had this lavish lifestyle, high standard of living, which husband admitted to, but he gave it no weight. You can weigh it. You can say, well, I'm considering all of these factors, but the judge didn't do that. So the special master.
What is your, I guess if the special master had to reach findings on these other factors, I find it hard to conclude as a matter of law that he didn't give them any weight at all.
Well, all you have to do is
the fact that he came out different than you would have liked him to is not necessarily a statement that he didn't weigh them. He just may not have weighed them the way that you preferred.
He found them to exist, and then he said, but because
this other factor weighs more heavily in my view.
He didn't say that. He just said, but because...
I don't have a transcript. We just have the order. But,
well,
yeah.
So we have to look at his order. And in the order, he literally says, because wife is able to support herself, I'm going to deny spousal maintenance. That was it. And that's not weighing to me. That's saying that what's happened here, and through the codification of that order by the trial judge, the 25319B has been turned into a litmus test. If you follow the special master's reasoning, that all of these other things can exist, there's a lot of precedent interpreting how important all these factors are, and yet if I find one factor that is true, wife can support herself, I deny spousal maintenance.
Well, listen, help me understand. Are you disputing the finding that she can support herself?
Yes.
How so?
Because it isn't just like, can I support myself? You can support yourself by living in a shelter. You know, if you go down to that standard of living, or a one-bedroom apartment, or a studio.
How much of her $44,000 in desired expenses could she cover on her $3 or $4 million of assets?
It has to be looked at, Your Honor, in terms of examining all of these factors, the equitableness of it, as Rainwater said.
But what one might conclude that under the statute, the most important factor is whether the spouse can support himself or herself. So my question is, what makes you think that was not, or what does the record tell us about why the master might have erred in concluding that she indeed could support herself?
Because support herself has to be looked at in a relative way, in terms of support herself in the prior standard to which she was accustomed to living, and we know that they were living on, basically up to $80,000 a month. And husband admitted that. So support herself and what he required her, and the other problem with this finding is what he required wife to do was the special master, again, adopted by the trial court, said, if you invest all of your money into this annuity, then you're going to have enough. Well, my goodness, what if wife doesn't want to invest all of her money into an annuity?
Well, does she have to?
Under the special master's analysis.
She's legally required to do that?
Well, no, but the way he gets to his result is by saying...
Isn't that just an example of what...
But
what
you see, Your Honor,
could be done?
Only if she takes all of her money in violation of all the cases, Gutierrez and even prior to that, that say you shouldn't be required to use up your retirement to get to where you can live off of it. He was requiring her.
I understand those cases, but those cases stand for the proposition that you don't have to start to dip into your nest egg when you're already at retirement age. I mean, I can't expect to live for my entire life without dipping into my retirement.
Well, yes, but if your spouse, if any of our spouses were, a level of, $20 million, and that's the standard that we're being judged by. He's saying that she has to give all of her money. If she converts all of her income into an annuity, she's going to end up with just this much, and then she's going to have $700,000 to invest on a house, and you can't micromanage like that. And that was the case of Anonymous Wife that suggested that. So I think you can't. My point is, Your Honor, you can't examine this in a vacuum. You have to examine this within the equitable way that Rainwater talks about. What does your husband have? Or it could work the other way. And then talk about standard of living, and then talk about, can you support yourself? And I want to get back to this $44,000 a month. I mean, again, we don't have a transcript, but we do know from the special master's report that he even rejected the fact that a request was made of it would cost wife 12. Her minimum overhead was 12 to 14,000 a month, and he rejected that proposal too. So it was an abuse of discretion as a matter of law to reject anything. You can't get from the top to zero. I just think it's unreasonable as a matter of law. And then I can answer other questions from the court on my reply, but I would like to reserve. But did you have another question? You look like you had one.
Thank you.
Thank you.
Good morning, Your Honors. Excuse me, and may it please the court, it's nice to see everyone this morning. My name is Scott Boehm. I represent, as appellate counsel, Dr. Cohen, the husband here, who is in his 80s now and long since retired from being a doc. It's probably no surprise to you that I'm going to start by talking about decisions that were made by wife and her prior lawyers. One of the things that we sometimes unfortunately learn as appellate lawyers is you have to play the hand that you were given. And decisions that were made long before Ms. Slayton's firm got involved on behalf of wife, in our view, drive the court's resolution of the opinion or of the appeal here. Starting, and I'll mention these quickly, but then I'll address the spousal maintenance thing that she talked mostly about. In their brief, there are issues that they're complaining about due process. The fact that Mr. Zarzinski acted as both the mediator and the special master, as well as the fact that there is no transcript or any other record of the proceedings, which of course impacts this court's standard of review on the two substantive issues on appeal, the meat of the order are the spousal maintenance and the attorney's fees. We don't have a record on them. The reason we don't have a record on them, and the reason that wife's appellate counsel is stuck with what went on before, is the stipulation that Mr. Zarzinski act in both roles. So that due process argument goes away by virtue of the stipulation. And of course, we're bound by stipulation. That's the Garn case that was one of my early appeals back in the 80s, a family law case that says if you make procedural decisions and your lawyer agrees to them, you're stuck with them. Same with regard to the absence of a record in this case. Under Rule 72, you're entitled to have a record, but you have to request them. Now, the rules that we're talking about, both 67 and 72, have been changed effective January 1, and since I'm not a family law lawyer, I had to go read all the new rules for this argument. But none of the substance of anything we're talking about has changed. It's all the same. And of course, the new rules don't apply, but to the extent the opinion oftentimes cites the new rules, all of the substantive requirements are exactly the same under both rules.
Well, help us with what are we reviewing here, and what is the standard of review? Is it, as I understand Rule 72, the family law master's report became the order of the court as a matter of law, and then there was a motion for new trial, new hearing. What's our standard of review, and what order are we reviewing?
I think, and I was going to get to that next because I disagree with wife's position on this. Our view on this, and maybe I have a different view for a different reason. I think the only issue that's legitimately before this court, and the only question at issue, is whether the trial court, the family law judge, abused his discretion in denying the motion for a new trial, or in this case, dismissing it, which is a semantic difference, as Judge Perkins pointed out. And let me walk you through why that happened. The special master report was issued on December 8, 2017. By both the parties' stipulation regarding the special master proceedings and also the specific terms of then Rule 72F, I'm not sure what the subsection is under the new rules, you have to object within 15 days, which brought their objection up to the day after Christmas. No objections were filed at all and 8 weeks go by And of course, within 10 days after that, as you pointed out, within 10 days after that, special master thinks so that would have been December 18th. If no objections are filed, or excuse me, I misspoke. Within 10 days after the expiration of the time for objections, that self-executing rule becomes an order of the court. Well, before they filed anything, the judge also expressly adopted it in a minute entry, which I have right here. February 1 minute entry, record on appeal number 48 is a minute entry that the judge formally adopted it.
On what day?
It was filed on dated February 1, filed February 5.
Okay.
So the judge had actually, and I'll explain this a little bit more in a minute, since it was done on the 1st, nothing had been filed, and by then we're 8 weeks past the deadline for filing your objections. That is when Ms. Slayton's firm got involved and filed their renewed objection to Zarzinski being both and the renewed objection to not having a transcript. Well, then everybody got the decree. This is the decree, all it is here. It incorporates by reference. Then she filed the motion for new trial, which said the same exact things as the renewed objection, that being he shouldn't have wore both hats, and he shouldn't have proceeded without a transcript. The problem, and I'm finally getting to the answer to your question, is the problem is that the time to object to the spousal maintenance ruling and the time to object to the attorney's fees ruling and any other thing that they would have had, any other objections they would have had, but those are the two that they apparently object to. That ship sailed on December 26th. So it was too late to bring those up in your renewed objection after the decree had been filed, and it was too late to bring those up in the motion for new trial.
You know, I see that argument in your briefs, but I look for Rule 72 cases that talk about this concept, and I couldn't find anything that says that you can't, that why family law and a family law master's report is different from the normal rule. You can always go back and raise a new issue in a motion for new trial. You might not do it successfully, but you can always, can't you?
Right, but the problem with that is what you're asking, and what the trial judge was, or I keep calling him trial judge, the family court judge, was asked to do was to revisit things that the special master had ruled upon without a record. So the fact that they, one, didn't object and never gave them a record, and they make all the same arguments they make here now, and I've got plenty of time left, so I do want to talk about the substance of it. But there's nothing, the trial court was in no better position than you are to be second guessing the special master, because he didn't have a transcript, he didn't have any of the other record, because there was none, because they, the prior counsel, Mr. Belt, who represented wife at the time, never requested one.
Although here, it wasn't as if the family law master was making findings of fact. He wasn't he wasn't resolving factual disputes. He was exercising discretion based on what I think sounds like a stipulated set of facts.
Well,
does that make a difference? And am I right? And
well,
does that make a
I think
difference?
you're wrong, actually.
Okay.
I'm not faulting you for that, because
Well,
there was no record.
tell me.
But we had an evidentiary hearing in this case. So there were 2 days of testimony, late October and early November of 2017, where their expert, Charlie Cretors, got up there and explained her rationale for her report, which isn't in the record anyway.
Is or is not?
Is not in the record. Nothing that was sent to the special masters in the record. They tried to bring it in on appeal, but this court said, no, you can't add stuff now. And the same thing, this is kind of a double-edged sword, because our side didn't request a transcript or submit anything either. So to the extent we would have lost or the rulings would have been unsatisfactory to us, we would have been in the same position of there's nothing to support these arguments. And we've all had cases before where if there's no record, then the court infers that the record would have been supported what the special master decided here. But on the merits of the
Counsel, before you move on,
Yeah, go ahead.
you mentioned that we're in just as good a spot, essentially, as the family court judge to rule. But doesn't that mean, or to me, that suggests that Judge Driggs, I think, was the trial
Yes,
judge,
correct.
that he had the obligation, at least, to make a good faith. I mean, to make a good faith run at those spousal maintenance factors, look at them, at least make sure that there's a reasonable basis for the ruling, and just like we're doing. I mean, in other words, I look at him as the first appeal almost. He's if we're going to do that, and the Supreme Court is looking over our shoulder, they're expecting us to show our work a little bit, right? That we looked at this, we evaluated. Did Judge Driggs ever show his work? I mean, say, I analyzed this. This makes sense. This is fair. Do we have anything like that?
No, and I don't think we have his ruling, obviously. And you have to keep in mind where Judge Driggs was at the time that he expressly adopted it. And again, it was self-executing, so it was somewhat of a perfunctory order by that time, although obviously we needed a signed order for a decree. But what he's in his mind at the time of February 1, when he signs the decree, there's no objections to anything that went on. They had 8 weeks at that point to have objected.
So you're saying the only time that he exercised any judicial function was in ruling on the motions, the post-decree motions?
Correct, although what we don't know, and I think this may be what Judge Brown's getting at, we don't know whether Judge Driggs sat down and read the special master report. Certainly it was properly filed, so it was all right there. But no one objected to it. I mean, 8 weeks. They had to say this is a problem, that's a problem, the other thing's a problem. None of that happened. So he just went ahead and signed the decree on February 1. And then out of the woodwork, within a few days later, he gets these objections that were frankly based on the due process. They really didn't, they wanted a do-over on the stipulations for Zarzinski acting in both roles, and a do-over on the whole darn trial with the record. And this is kind of a dilemma of their own making. And and as I told Mr. Jensen when he called me, if this evidentiary hearing doesn't go the way you want it, and you don't have a transcript, well, too bad, so sad for you. And he took the risk, as did the wife. But I don't know how this court is expected to second guess the evidence that doesn't exist before you. Now, on the spousal maintenance award itself, as Judge Perkins, you accurately pointed out, the judge went through, or the special master went through individually all of the factors under 25-319, and some of them didn't apply. Some of them weighed in favor of both sides, but the big one here, and the one that they're complaining about, is the fact that wife is self-sufficient. And Charlie Cretors, her expert on this issue, explained at the hearing and in her report, neither of which are in the record again, that she was self-sufficient. The judge talked. What is in the record?
We don't know what she explained at the hearing.
We don't.
Well, what we do know is the judge.
What found its way into the report.
Yeah, and he explained that her testimony and her report was unbelievable. I forget the words he used, but he said not credible and unbelievable, because 30 days before the evidentiary hearing, wife submitted a AFI of the amount of money that she needed to pay all her expenses. And it came out to $12,820 or whatever it was, $12,800, let's say. But they wanted $44,000 so that, and this is expressly, so that wife could keep all of her own money. And the point you made, Judge, is right on. I'm retiring in August, and I'm going to have to start spending my retirement money. That's what it's for. And this is not a 28-year-old couple who need to keep their money for when they retire. She's 70. He's in his 80s. They're retired. And the cases that they cited, they complained about Deathridge, but it says the same thing as Gutierrez, which they prefer, is you can't require people to use up their retirement assets to live on before they get to retirement. Well, these folks are in retirement. So, of course, that's what it's for. And their expert cretors, as the judge, as the special master pointed out in his ruling, conceded that she had 4 different alternatives that she tested. None of those are in the record, but I'm telling you what they are. He explained them in the ruling. But one of her alternatives was this annuity idea, and it was uncontested. Both sides. Our guy came out with even a better situation for her with the same annuity. But if she took the annuity payments plus her Social Security, and it's a $2.5 million annuity, she pays for the entire $12,800 that she needed, and she submitted the AFI on 30 days earlier. So she's still got, and she's not using up. The purpose of this annuity is a lifetime annuity. She's not burning through it by the time she's 80. It's going to be there forever. That was the whole idea. Same with the residual money that she had left over after that annuity. She's going to get $4.4 million. Granted, husband got a lot more, but it's all his sole and separate money. And what she asked for, this $44,000, so she could become a philanthropist and keep all of her own money and build a legacy that she could leave to her family and others. There's no basis for any of that. She was asking, and the Cretors was asking, and the special master explains this. She was asking husband out of his sole and separate property, and there's no suggestion anywhere in this case that the wealth with which husband came to this marriage is in any way community. It was all in his own IRA that he got lucky on an investment when he was a young doc, and was lucky enough or smart enough never to commingle anything. So all of that saved. And same with wife. She had $1.5 million or $1.4 million in what he found in IRA money. So between the house and her own IRA and half of the $3 million they had in community, she's got $4.4 million to live on. That's a lot of dough. And she only needs $12,000 a month. So both experts agreed, and the judge explains all this in the ruling. Even without a record, the ruling says this, the special master, that she's got, her needs are met with Social Security and the annuity. That still leaves her $1.9 million to be a philanthropist or do whatever the heck she wants. She testified at trial that at the evidentiary hearing, again in the ruling, that she needs $600,000 or $700,000 of that to buy a nice house, which leaves, and he does all the math right in there, that leaves her 1.2 to do whatever the heck she wants. But she wants him to pay based on nothing. I mean, I don't know how wife can find an abuse of discretion in the spousal maintenance ruling. Even if you get to that, and I still don't think you get to it, I think they punted on all her objections and you know, who knows what the excuse is. Maybe she was unhappy with the way it came out and she was scrambling to find another lawyer, but the 15 days went by, plus another 6 weeks after that, when no one squawked at all. And it's just too late now to come in and start griping about it. Now, the attorney's fees, and I got 14 seconds left. I'm not even going to waste your time. Thank you very much. I appreciate it.
Thank you.
Your Honors, I just want to bring to your attention something that isn't correct, okay? And it's in the index of record. I'd like you to please note that our consolidated, renewed, it's number 46 of the index of record. Our consolidated renewed objection to John Zarzinski as family law master, objection to his filed report, and motion for new hearing before the court was filed February 3rd. Very important. Number 48 was the order of the court that was filed, and we all know it's the date of filing that counts.
How is that significant, though?
Because one of the things opposing counsel relied on is that he already accepted the report and entered the decree or accepted the report, I should say, by the time I filed my renewed objection, and that's just not true. We filed our renewed objection before that report was adopted.
Actually take action to accept the report, or isn't it, as counsel pointed out, kind of a self-executing, for lack of a better?
Whatever it means, that report was not adopted until after we filed our renewed objection.
The rule doesn't operate to cause it to be adopted.
He didn't adopt it. He filed that order.
I understand what you're saying about the judge. I'm asking.
I believe that's a big deal because.
But if you could focus on my question is, does the rule operate to essentially self-executingly adopt without action of the court? So you dispute that reading of the rule? You guys?
I don't think it self-executes. Okay. I think it gets back to what Judge Brown was saying. The judge is not, the family law judge is not, and into a certain degree what Judge Johnson was saying, this isn't a rubber stamp situation. You can raise your issues always in family court again. And I have to bring out, Your Honor, that this is also very important. We did, when I say we, I mean trial counsel, prior counsel, Mr. Belt, he did challenge the dual rule of Mr. Zarzinski, mediator versus arbitrator. He objected to it. It was a written motion. He brought out all of the problems with that. And I don't have time to lay them all out now, but the rules 67 and 70 really are very clear that a mediator is a mediator, an arbitrator is a special master is a special master. You shouldn't do both for lots of different reasons. And so he objected to that before the fact. And if
your client had prior to that stipulated to this
yes, Your
process.
Honor, she did, but through her counsel. But let me just say, there's nothing in the rule, in the stipulation, or the proposed order, which says Mrs. Cohen was advised, and why would she know that, of the fact that if she hadn't stipulated to it, it wouldn't be allowed. Like they should be separate. Nobody went over that with her on the record. The order of the court did not reflect that. So in other words, and we cited a case for this in our brief, you have to be, in order to comply with due process, you should at least be told of your right. Same thing, so that's a really big deal.
So are you saying it was the court's obligation or her counsel's obligation?
I think it was the court's. I think if the court
was obligated to say, I know you've stipulated to this, but
yes,
you should know that that was a mistake?
You should know that you have the right to have two separate people.
Well, why would the court presume she didn't know that, as opposed to the court presuming that her counsel advised her and she opted for a different?
Well, but then, Your Honor, I agree. But then, Your Honor, Mr. Belt did bring up all those problems. And he brought up those problems before a hearing was even held. He brought up those problems when it was possible for the court to say, well, if you now realize this through your counsel, Mrs. Cohen, I think that's a valid point, and I'm going to ask for two separate people to be appointed. I mean, this isn't just a gamesmanship. A divorce proceeding, although it's not a criminal matter, it's the most important proceeding that you can have in your life, other than something criminal. It's adjudicating everything. This was a 30-year marriage, so you want that to be fair, and that coupled with the fact that there was no transcript, I want to address that briefly too. Yes, the party has to request a transcript, but I think it's important that the special master, that somebody put on the record, since there is no transcript, in the ruling itself. Mrs. Wife and husband were both advised that they had the right to request a transcript, and they decided not to do that. That's not even in the report. We don't even know what happened. So these are basic rights that we're talking about. And I believe that this was so many things happened here. The fact that no transcript, same judge as mediator as arbitrator, an incredible ruling of spousal maintenance of 0 when the husband has $88,000 a month and then we don't even know what happened. I mean, there are basic rights that people have to be able to come up to a court of appeals on a real transcript, that's missing here. And so I think that it's everything together. I think this has to go back. I think her due process was violated, and I think the special master through the court made an abuse of discretion as a matter of law on this.
All right. Thank you.
Thank you.
Thank you to both sides for your argument and your briefing. We'll take the matter under advisement and issue a decision in due course. Now we will adjourn.